Ayaram Gayaram is a famous Hindi saying in Indian politics. The reason for that is Haryana MLA Gayalal, when in 1967 he changed his party thrice in a short period of time, from Congress to United Front, then again to Congress, then again to United Front. This was one of the earliest incident of defection in the country. Similar situation happened in 1970 when government led by Morarji Desai collapsed due to the number of defections taken place by the legislators to join another political party, Bharatiya Lok Dal, led by Charan Singh. Hello, I am Dr. Anju Puneet Singh, teaching in National Law University, Delhi. Today, we will discuss the module on anti-defection law and Schedule 10 under the Indian Constitution. The learning objective of this module we will study the provisions which were added in the Indian Constitution via 52nd Amendment in 1985 and whether there are any exceptions to this anti-defection law. Anti-defection law was passed in India in 1985. Now, 33 years down the road, it is relevant to see what modification has been brought by this law in the Indian political scenario. But before discussing what anti-defection law is under the Indian Constitution, let us discuss what defection means. Defection means when one member of a political party joins another political party for some benefits. Benefits can be monetary, can be ministerial post or any other. Advanced Law Lexicon Dictionary defines defection as crossing the floor by the member. This is the reason in United Kingdom defection is also known as floor crossing. Similarly, in Nigeria, it is known as carpet crossing. One of the first attempts to draft anti-defection law was made by Rajiv Gandhi, the then Prime Minister of India, though it took long time. For the first time in 1967, Lok Sabha appointed a committee known as Committee on Defection. This committee submitted its report in January 1969, wherein it highlighted the alarming rise in the number of defection which takes place. Usually, this defection was by the same person or by the same set of persons for bribery, corruption or any other benefit. Examples can be when in 1993, 6 MPs from Jharkhand Mukti Morcha took bribe from the Congress led by P.V. Narasimha Rao to vote in their favor. Supreme Court in that case held the bribe givers are culprit in this case. Later on, similar thing happened in 2007 when Raja Rampal Singh and other legislators caught taking bribe in a sting operation conducted by Aaj Tak. These members were held guilty for taking bribe and subsequently they were disqualified also. Now, when Committee on Defection submitted its report in 1969, pursuant to this recommendation, 32nd Amendment Act was brought in the year 1973. This Amendment Act provided for similar recommendation as the Committee on Defection has given. This amendment was not passed due to the lapse of the Parliament. Later on, again in the year 1979, similar efforts were made in 48th Amendment Act. Once again, it was not passed due to the dissolution of the House. But lastly, in the year 1985, under the 52nd Amendment Act, anti-defection law was adopted and a new schedule, 10th schedule, was added in the Indian Constitution. This schedule provided for the grounds on which member can be disqualified in case of defection. Who has the power to decide these matters? Whether there are any exceptions to it. What happens in case of merger of political party? What are the conditions of disqualification? And lot more. The scope of this act was that it wanted to strengthen the political democracy in the country by curbing unprincipled and unethical practices by political parties. Thus, it would not be wrong to say that the object of this act was to curb the evil of defection in the country. Now, let us discuss anti-defection provisions. Para 2 of anti-defection law provides as member would be disqualified if he voluntarily gives up his membership or he votes or abstain from voting as per the directions issued by the political party. That means a member of a political party can be disqualified when he voluntarily gives up his membership or he votes or abstain from voting. Now, when we are talking about voting, if the member of a political party is given the freedom to vote as he thinks fit, it would affect the public image and popularity of a political party. Not only that, it would also undermine the public confidence in that political party, since there would not be any unanimity in the decision. When a political party functions, it functions on the shared belief of its member. If the member are disloyal, they should be disqualified. That is provided under anti-defection law in the Indian Constitution. In this module, we discussed about what do we mean by defection? What was the historical background and adoption of anti-defection law in India, when a member of a political party can be disqualified on the ground of defection. In the next video, we will discuss the analysis of anti-defection law. What happens in case of merger of a political party? What option a member of political party have in case of merger? Is there any exception to that? And various examples, cases which had happened in the past to understand anti-defection law in the country.